So for our final topic, we come to the concept of preemption. And I think preemption is a good topic to end on because the constitutional law that's at issue here is fairly minimal, so there's not a whole lot new to learn. The bulk of the preemption analysis, the really hard work with preemption problems, almost always lies in the statutory interpretation. So we'll look at the case that was in the casebook today from Illinois by going through some of that statutory interpretation, but you certainly don't want to lose sight of the underlying constitutional issue, which is governed here by the Supremacy Clause. So I'll try to, as we're going through the case, point out when we're dealing with a constitutional matter versus a statutory interpretation matter. So the clause that we're concerned with is the Supremacy Clause, a clause that we are very familiar with. To remind yourself, this is the very last substantive article, the Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land. So the relevant portion here for preemption purposes is that the laws of the United States, including the laws, which are the laws that Congress passes, are supreme to any state law, right? Anything in the constitutional laws of any state to the contrary notwithstanding. So preemption is sort of prefigured here or implied, implicit in the Supremacy Clause, that the law of the United States is supreme regardless of any law of any state, to the contrary notwithstanding. So the only other thing that you would need to know, besides the question of whether or not there is some incompatibility between the laws of the United States and the laws of any particular state, is you will need to make sure that the actual federal law is constitutional. So the Supremacy Clause only makes supreme the laws of the United States which are made in pursuance thereof, that is, that are made in pursuance of the Constitution. So if you were doing a full-blown analysis on a statute where preemption was an issue, you would probably first want to make sure that the actual federal law that is claimed to preempt the state law is in fact itself constitutional. So that leads me to the next slide here on the vocabulary that gets used within the field of preemption. So a state law or a state action, what the situation arises when a state law or a state action conflicts with some sort of positive law that is enacted by Congress. So there's some statute that Congress enacts, or there's a federal regulation that an administrative agency has promulgated and finalized, and the state law is incompatible with either the federal statute or the federal regulation. Then we say that state law is preempted by, and then whatever it is preempted by the Environmental Protection Act, or is preempted by some particular regulation from the EPA. Different language than when a state law conflicts directly with the U.S. Constitution, right? Also, the rule that a state law is void because of a lack of constitutionality also comes from the Supremacy Clause, but the point being here that the Supremacy Clause can invalidate a state statute then for one of two reasons. One, because it's unconstitutional, or two, because it's preempted by a valid federal law. Right? So if the state law conflicted directly with the Constitution, we might say that state statute violates the Dormant Commerce Clause. Right? But we wouldn't say that the state law violates the Environmental Protection Act. We would say that the state law is preempted by the Environmental Protection Act. And then just to round things out here, a federal statute might also be unconstitutional, but there is no preemption concept that would apply to a federal statute. Right? A federal statute would never be preempted by anything. All right, so what sorts of preemption do we have? If you look at the majority opinion written by Justice O'Connor and the dissenting opinion written by Justice Souter, you'll see them list several different types of preemption, and I think Justice O'Connor says there are at least two types of preemption. And then Justice Souter says that there are three types of preemption. So I'll try to break this down for you here with this organization. The two types that Justice O'Connor initially mentions are express and implied preemption. So express preemption would occur when Congress says in the text of the statute, this statute prevents states from passing any legislation on the same subject matter. Or it will say something like, the remedies contained in this statute supersede any similar remedies found in state statutes or in state common law. So express preemption, there's some language that you can point to in the federal statute that says that it will take precedence over any state law to the contrary. Implied preemption arises when the federal statute is not so specific, but enough of the language of the statute, enough of the effects of the statute suggests that it is intended to be the only regulation on this particular topic. Now, within the heading of implied preemption, there can be several different types of implied preemption. There is something that is called conflict preemption, and there's something that's called field preemption. Right? And these are if we're looking at the way that Justice Souter counts things up, he would count them up as being three things. He would say there's express preemption, there's conflict preemption, and there's field preemption. So conflict preemption itself, however, can come in two different varieties. There can be conflict preemption that we sometimes call direct conflict preemption or impossibility preemption. This is where it is actually impossible to comply with both a state statute and a federal statute. Right? The federal statute says you must do X, and the state statute says you must not do X. And so it's literally impossible to comply with both statutes. That would be although the federal statute doesn't say by its terms that states can't legislate on this matter. It's simply impossible to comply with both the federal and the state statute, and that would be a situation of impossibility preemption or implied conflict preemption, and the state statute would have to be invalidated. The court would have to hold that it was preempted by the federal statute. The other type of implied conflict preemption is what is sometimes called obstacle preemption. So this is where it's not literally impossible to comply with both statutes, but if you comply with the state statute, you're posing an obstacle to the accomplishment of the federal goal. Right? So the state statute throws up some obstacles to the underlying federal statutory scheme. And then the last one here, the field preemption, this is the situation where the statutory scheme that Congress passes is pretty extensive. So usually this is the situation where it's more than just one little statute, one little federal statute that we're worried about. Usually it's an entire realm of regulation. So for example, aviation would be one area where, and I think this is given as an example in the notes at the end of the book, the regulation of flights is under Congress has passed legislation. They've created a federal executive agency, the FAA, that regulates this. So the idea is the field is so well and comprehensively regulated by the federal government that there really isn't any room for states to be regulating in this field. And you might not be able to point to an obstacle that one particular state statute would pose, but the idea is the field is just so completely regulated by the federal government that there really isn't any room for the states to have their own regulations. So that would be field preemption. So what sort of preemption do we have here with the Occupational Safety and Health Act, the OSH Act, that is at issue here? Notice that the members of the court themselves can't seem to agree on this. So that hopefully helps you understand that those categories on the previous slide aren't hard and fast categories. They're not it's not always clear which one should be invoked. So here we have actually a plurality opinion written by Justice O'Connor, and then Justice Kennedy provides the fifth vote, but they find very different types of preemption. The plurality written by Justice O'Connor finds implied conflict preemption, and Justice Kennedy finds express preemption, and then Justice Souter would find no preemption at all. So what does the Occupational Safety and Health Act do? The idea here is to regulate employment such that workers are going to be protected, such that workers are going to have the sorts of working conditions that promote their health and safety. With respect to this particular statute that's at issue here, coming from Illinois, and where the potential conflict lies, the OSH Act requires that individuals who are employed in the hazardous waste disposal field undergo some sort of training, right? So the training helps to protect the safety and the health of the workers. All right, so the relevant statute is given in bits and pieces throughout the opinion. I'm going to lay it out here on this slide. It might help to actually have the statute printed out, or to print out at least this slide, have it in front of you in some way as we go through the rest of the opinion. So the statute, the relevant provisions that the court invokes in its interpretation here are these, well, at the very least, these four here. So the first part of the Act says, nothing in this chapter shall prevent any state, agency, or court from asserting jurisdiction under state law over any occupational safety or health issue with respect to which no standard is in effect under 655 of this title. So let me just be a little clearer on what the two statutes require with respect to people engaged in the hazardous waste disposal business. So if you look at the federal statute, the OSH Act, this required that individuals, workers who were engaged in the handling of hazardous waste, must receive a minimum of 40 hours of off-site instruction. So that's one of the requirements of the Act. And then if we compare it to the Illinois requirement, Illinois also required 40 hours of training, but of Illinois-specific training. So you can see that the Illinois statute is essentially adding to the requirements that someone engaged in this line of business would have to undergo. They also had, for another example of where we see a difference, Illinois said that anyone who was involved in crane operations dealing with hazardous waste would have to undergo 4,000 hours of training. The difference between the federal regulation and the state regulation were quite extreme. The federal regulation contained here in the OSH Act said that someone who operated a crane that was moving hazardous waste had to undergo 3 days of field experience before they were certified. That 4,000 hours that Illinois required more or less translated into 500 days of experience. So you can see the Illinois Act was putting much higher hurdles in place in the name of worker health and safety. We'll also look at what other reasons Illinois had in place, but just so you have an idea of what's going on here. The federal statute has some requirements, some training requirements. The Illinois statute also had training requirements, just more of them. So what does the federal statute actually say with respect to this idea of states being in the business of regulating worker health and safety? So the first one says, nothing in this chapter shall prevent any state from asserting jurisdiction under state law over occupational safety or health issue with respect to which no standard is in effect under 655 of this title. So everyone seems to agree that at the very least, this first part of the statute says that if there is no federal standard that's at issue, if the federal government never regulated it, then no state's law should ever be thought to pose any problem here. B says any state which desires to assume responsibility for development and enforcement therein of occupational safety and health standards relating to any occupational safety or health issue with respect to which a federal standard has been promulgated, the state shall submit a plan for the development of such standards and their enforcement. So here, what Congress is doing is it's trying to develop a way where states could take over entirely the regulation of employee health and safety if they wanted to. They could submit the plan to the federal government, right? And the way they do it is they submit a plan to the secretary, and then the secretary approves that plan. But the idea here, and this is the part of the statute where there will be a lot of disagreement over what exactly this means or what the implications are from this. But it's pretty clear that states can, if they want to, write laws that in and of themselves supersede any federal law, so long as the federal government approves the state's plan. So the secretary can approve the plan. There's a big list of things that the secretary has to look for before he or she approves a state's plan. And one of the things that's important to the court here, one of the things that the secretary has to look for in the state's proposed laws is whether or not the state's laws would unduly burden interstate commerce. So that's one of the things the secretary has to look out for. And then we're also told that the secretary can always withdraw approval of state plans that have previously been approved if there is some sort of failure to comply with the some other federal regulations, with the criteria that are contained in subsection C. All right, so that's those are the important parts of the Act that help to answer the question whether or not the Illinois statute is preempted by this particular statute here. So we'll come back to this, but just remember the general outline here. There's a introductory provision here that says nothing should be construed as being prohibited if there isn't a federal regulation in place. B says there's a way that states can have their own laws control instead of federal laws. C describes how the secretary goes about approving those state laws. And then F provides the secretary with the ability to withdraw approval of previously approved state plans. All right, so the statute that's at issue here is an Illinois statute that involves the licensing of people in this hazardous waste disposal field, and the court calls it a dual impact statute. What they mean by dual impact statute is that Illinois says that these licensing statutes were designed to do two things. One thing they were designed to do was to regulate worker health and safety. So Illinois is just as concerned about the safety of workers in this field as the federal government is. So here, there's a parallel between the statutes and the statute's purpose and the federal statute's purpose. But another thing that the Illinois statute claims to be doing is environmental regulation. So unlike the OSH Act, this particular, or these pair of Illinois statutes also claim to be engaged in environmental protection. So we want well-trained workers, not just for the workers' own safety, but we want well-trained workers dealing with hazardous waste so that they don't accidentally drop it and pollute the environment, which would be a harm for everyone, not just the workers. So does the federal act preempt these state laws? And the court will tell us yes, because the state laws conflict with the purposes and the objectives of the OSH Act, of the federal act. So the court will categorize this as a conflict preemption, and then we want to know how the court goes about determining that there is a conflict here. Again, as I mentioned up front, note that this part of the opinion, part 2 of the opinion, is a plurality opinion because Justice Kennedy doesn't agree that this is a situation of implied conflict preemption. Then part 3 of the opinion, so we'll come back to the substance of part 2 in just a minute. Part 3 of the opinion on page 394 is a majority opinion there, and the court asks the question, even if the federal act preempts state laws that have the same purpose as the federal law, does the federal statute preempt state statutes that have an independent traditional police powers purpose? In other words, is the Illinois law... So, assuming that what the court discovers in part 2 of the opinion suggests that state laws that attempt to regulate worker health and safety are preempted because that's the same topic upon which the federal statute is regulating. If a state statute also has a purpose that's unrelated to the purpose of the federal statute, does that somehow save the statute from preemption? And the court will answer no. So even if the statute preempts laws that have the same purpose, does it preempt statutes that have an independent purpose? And the court says yes, it preempts statutes that have a different purpose as well, because what's important is not really the state's purpose. What's important is the state law's actual effect. So we'll look at that. So how does the court get to implied preemption here? And again, this is the work of the statutory interpretation. The constitutional principles are, if you have a valid federal law and an incompatible state statute, that state statute must fall. It must take a back seat to the federal regulation. So the court says we should start out by looking at what the congressional intent was. Hopefully you'll have a chance during the next 2 years to take a class on statutory interpretation. I would highly recommend it. You'll learn that one of the starting points for any statutory interpretation is to ask what the legislative intent was. Now, usually courts will say that the best place to glean legislative intent is from the words of the statute itself. Here, the court says that the legislative intent was to have employers and workers answer only to one set of regulations. How do we know what the intent of any particular piece of legislation is? And the court here answers the question by saying that we should look to the structure and the purpose of the statute as a whole in answering the question about intent. So this is on the middle of page 392 after the court has explained the different types of preemption. Right? Our ultimate task in any preemption case is to determine whether state regulation is consistent with the structure and purpose of the statute as a whole. So the court then looks to the statutory structure, and by statutory structure, when a court refers to a statute structure, it means to look at all parts of the statute, not just the particular words or sentence that are under review. So you need to look at how Clause A or subsection A interacts with subsection B, and how the whole thing maybe interacts with the statute that's immediately before it or immediately after it. So the thought is the statutory system is a set of interlocking parts, and you need to understand how everything fits together. So the structure, how does the structure help us? Well, the court says, let's look at section 18A first. So section 18A, the court calls a saving clause. And the saving clause says that if there is no federal regulation, then the statute doesn't interfere with any state law. But the court says the natural implication of that saving clause, this is the middle of page 393, the court says the natural implication of that saving clause is that if there is a federal regulation, then the state statute is preempted, right? Because the court says, why else would Congress have said that state laws aren't preempted if there isn't federal regulation? Why would they have included that if they didn't mean to imply, although they didn't expressly state it, if they didn't mean to imply that if there is a federal regulation, then state statutes are preempted? The court also looks at subsection B, the ability of states to And the language of 18b says that states can preempt federal law. That can get confusing, but that's just the way that Congress wrote the statute. But the idea here being that states can have their own law govern if they get approval from the federal government. The court says that this provides the only mechanism through which state laws will take precedence over federal law, and therefore this is the only way that states can pass laws. And we're told that Illinois did not take advantage of having their own set of laws approved by the Secretary, and therefore this provision couldn't be used to uphold Illinois' statute. But in fact, it can be used as in an argument striking it down, because the court says this is the only way that Congress intended state laws on the same subject to be in force. And then what about the approval criteria? The court says that the Secretary has to look for certain things before he or she approves a state's proposed plan. One of the things that the Secretary has to look for is that the Secretary has to make sure that the state's proposed laws don't unduly burden interstate commerce. And one argument had been that so long as the state statute is supplementary to the federal statute and doesn't actually, it's not in direct conflict, it doesn't seem to be having a policy goal that's directly at odds with the federal policy goal, that the state should be allowed to supplement the federal law nevertheless. So remember how Illinois was supplementing it. The federal law said you need 3 days of training. Illinois says, no, you need 500 days of training. So altogether, you would need 503 days of training. And Illinois wants to argue, but there's no preemption there, because Illinois isn't undermining the federal statute in any way. It's just adding to it. It's supplementing to it. And the court says, but 18C wouldn't make sense if states could supplement federal legislation without going through subsection B here. Because a state statute then could potentially interfere with interstate commerce, and the Secretary wouldn't be able to pass on that. So the court asks the question, why would Congress want to allow state statutes that never get checked for this problem of interfering with interstate commerce, and but nevertheless would allow the Secretary to veto some state statutes that are submitted to him or her via the method of subsection 18b. So the court concludes that Congress couldn't possibly have wanted this to happen, where you have some state laws that must be submitted under 18b if they're to take effect, but other laws that could take effect, that could supplement, but never be submitted through 18b. The court says it doesn't make sense to have two different tracks, essentially, of ways that state laws can be in effect. And then adding to that argument, the court points out that the Secretary can always withdraw approval of the regulations that were approved under 18b. And furthering the argument that there really shouldn't be two tracks of laws that can follow two different tracks, laws that are merely supplementary and laws that would need 18b approval. So the conclusion then is that the federal statute doesn't allow states to supplement federal standards, and the fear is that the states might interfere with the federal methods for achieving a particular federal goal. The court says that at the end of section 2, page 394. But if we go to part 3, we see the court also hold that the preemptive effect of this federal statute is limited to state workplace health and safety legislation. So the court points out at the middle of page 395 that state legislation that is of a generally applicable nature, such as a general traffic laws, so let's say that the truck that is driving the hazardous waste down the road, that truck still must comply with local state traffic laws. The only preemptive effect that the federal statute has here is a federal statute that would regulate the same thing, the workplace health and safety legislation that the federal statute is regulating, or as the court puts it in the last paragraph on page 395, in some a state law requirement that directly, substantially, and specifically regulates occupational health and safety. In other words, the subject of the federal statute is within the meaning of the act. So that's the only sort of thing that's preempted by the federal act. All right. So Justice Kennedy concurs. He provides the fifth vote for holding that the state statute is preempted by the federal law. His critique and the reasons that he doesn't join the plurality opinion, he thinks that the plurality has based its conclusion that the federal statute conflicts with the state statute based upon purpose rather than what he calls a direct conflict or a direct contradiction with the federal legislation. So in other words, Justice Kennedy is saying that there shouldn't be a category of preemption known as conflict with the purpose of the statute preemption. He says there should only be preemption, there should only be conflict preemption if the conflict is with the carrying out of both pieces of legislation. So that sort of direct conflict preemption, that sort of impossibility preemption. But this idea that a state statute can conflict with a federal statute because it conflicts with the purpose, Justice Kennedy doesn't accept that as a valid type of preemption. Right? Because there's no direct conflict here, right? It's possible to comply with both the federal law and the state law. You just might need to do double the training, but it's not impossible to comply with both statutes. And therefore, Kennedy is saying that there is no conflict of the sort that would cause preemption. The other criticism that he has here is that when you use one of the categories under the heading implied preemption, there's this rule of statutory interpretation, this canon of statutory interpretation that the Supreme Court has long honored, which is this, that preemption is not to be implied. You shouldn't interpret a federal statute as implying preemption of state law unless there's a clear statement in the federal legislation. And this is especially true in areas of federal legislation that regulate what otherwise had been traditionally state-regulated areas. And the court does note at the very beginning of this case that worker safety had traditionally been an area that was left to the states. Why have this canon, this presumption, this statutory canon of interpretation? Well, the idea had been, and the court still accepts this, the idea is that Congress doesn't willingly displace state law unless it's crystal clear that it intends to displace state law. So an implied preemption shouldn't be easily found. Now, express preemption is an easy case because it says right there in the statute, this federal statute preempts state law. But it's when you get to the implied situations that the court is not supposed to find preemption very easily. But the majority is satisfied that yes, this is an implied preemption case, but it's clear enough that that's what Congress wanted. Justice Kennedy says he wouldn't get to implied preemption because he actually thinks that the statute expressly preempts state laws. And where does he find the express preemption? Well, it's in subsection B. It's the part that allows the states to submit their own plans for regulating worker health and safety. So the middle of page 397, he says that if we look, and this is the indented paragraph that he quotes on page 397, so let's look at it again. Any state which desires to assume responsibility for development and enforcement therein of occupational safety and health standards relating to any occupational safety and health issue with respect to which a federal standard has been promulgated shall submit a plan. So he says that this is, the very next paragraph, he says the statute is clear. The most reasonable inference from this language is that when a state does not submit and secure approval of a state plan, it may not enforce occupational safety and health standards in that area. So for Justice Kennedy, the fact that Congress expressly allows for states to submit their own plans that would take precedence over any federal standard, that, he says, you can draw the inference that there's essentially a negative contained in there, that unless the state does this, then the state cannot possibly regulate in the same area. He calls that express, although that seems far from express. The statute doesn't say anything about what states can't do. It says what a state can do, but from that, he would draw an express statement or an express sentiment that states can't act the way that Illinois acted here. All right, Justice Souter's dissent starts out with the same canon of statutory interpretation that Justice Kennedy did. So he first points out that the entire statute can be read to permit non-contradictory federal and state regulations to coexist. So in other words, state statutes that truly supplement and don't interfere with the state statute can coexist. And then applying that canon of interpretation, Justice Souter says, because there is this presumption against preemption, and since we can read the statute in a way that would allow both state and federal statutes to coexist, then the court must adopt that reading of the federal statute. And Justice Souter has his own reading of all of these different subsections. He says, look, we can read that savings clause in a way that comports with allowing supplementary state legislation. So the savings clause had said that if there is no federal regulation, then there's no problem for any state law. And remember, the majority or the plurality had concluded that the implication of that was that if there is a federal regulation, then there can't be a state law. And Justice Souter says, no. Justice Souter says, the best reading of that, this is the bottom of page 398, he says that understanding doubly errs, and then he gives his two reasons for why he thinks the majority is incorrect on that point. But essentially, he sees that as being a way to discuss field preemption that Congress didn't want to completely oust the states. And so Justice Souter is really saying we should read it for what it is. It is an express statement of Congress that it doesn't want courts to read state laws as being preempted. And we shouldn't imply that the opposite is true, that there are certain situations under which state laws should be preempted, because the statute doesn't say that by its terms. What does Justice Souter do with this 18b, which is important to both the plurality and Justice Kennedy? Justice Kennedy, in fact, draws his express preemption from this subsection alone. And Justice Souter's point is sort of similar to his point on 18a, that you're reading far too much into this particular ability of states to completely supplant federal statutes that would potentially be in conflict with the state law. So Justice Souter says, of course it makes sense to require federal approval if the state statutes that the state is proposing would be in conflict with the federal law, and you want the state law instead of the federal law to govern, then it makes sense to have this approval process. But Justice Souter says, this provision doesn't say anything about state statutes that wouldn't actually interfere with the federal regulation. This doesn't say anything about state statutes that could be complied with while at the same time complying with the federal regulations. And then what about Section 18C? Remember, Section 18C is where the plurality said that we couldn't possibly have supplemental statutes because the statutory scheme as written gave the secretary certain criteria that he or she had to look into to make sure that the state was following. One of those criteria was that your state laws couldn't unduly burden interstate commerce. And Justice Souter says that the majority has completely misread that as well. That is actually not to be read as a limitation on the state's laws, but that's actually to be read as a limitation on the secretary's approval powers. And we know from the Dormant Commerce Clause, well, first of all, Justice Souter says, look, if there is a state law that is unduly burdensome of interstate commerce, the Dormant Commerce Clause in and of itself will take care of that. But Justice Souter says, 18C is better read as Congress's limit not on the states but on the Secretary. As we know from the Dormant Commerce Clause that we just finished studying, one of the exceptions is that Congress can approve state laws that would otherwise be violations of the Dormant Commerce Clause. So here it looks like Congress is limiting the ability of the Secretary. It's limiting what powers it's delegating to the Secretary, and it's saying, look, we, Congress, can approve state laws that unduly burden commerce, but we don't want you, the Secretary, to be approving state laws that would be unduly burdening commerce. So Justice Souter says that the majority has completely misread that provision as well. Right? And his conclusion is that each provision can be read consistently with others without any implication of preemptive intent. And because that is a possible reading, it must be the reading that the court adopts because of this canon against implying preemption without a clear statement from Congress. All right, so the statutory interpretation here is somewhat complex. And that might be an understatement, especially if you haven't studied statutory interpretation to any great extent. But the constitutional principle is relatively clear, right? You have a federal statute that interferes. You have a state statute that interferes with a federal statute. The federal statute always takes precedence under the Supremacy Clause. The tough question is, how do you know when that state statute is actually interfering with the federal statute? And the basic dichotomy is express or implied. So the state statute might be expressly preempted. Congress might say there in black and white, no state laws on this subject. That should be easy enough to see, but the statute that Congress passes might not be so clear, and the court has found ways to imply preemption, to imply preemptive intent from the words of Congress without them expressly saying so. But the court is generally going to limit what sorts of state statutes get preempted based on the subject matter of the federal statute. So the important point to reemphasize here is, even though the majority finds preemption here, they limit what is preempted to those state laws that directly, substantially, and specifically regulate the same subject matter as the federal statute. You might also want to note the odd makeup of the court here. If you look at the majority and the dissenting opinion, you have Justice Thomas joining the dissenting opinion, and you might usually think of him as being with the group that was in the majority here. And I mentioned that the Dormant Commerce Clause can divide some of the conservative justices sometimes between those who are more textual, finding that the Dormant Commerce Clause doesn't actually appear in the text of the Constitution, and those who believe that it's good policy to protect the free market, and maybe even the Constitution requires that. Here you also see a split amongst conservatives on a number of these preemption cases because you have two competing preferences here. One is a basic states' rights preference, right? That you shouldn't interfere with state law. You don't want federal law displacing state law. And we've seen all sorts of ways that preference has been implemented throughout the semester, limiting the powers of Congress in the name of letting the states regulate in that area. So you can see why someone like Justice Thomas then might find this presumption against preemption to be particularly strong. But then you also have members of the court who are sort of like the members who like the Dormant Commerce Clause. Here we would have a state statute that would impose a great degree of regulation on business and on industry. And members of the court who are of that ilk, who believe in the free market, find these sorts of state regulations to be especially onerous, and they're more likely to find that the federal law, which is usually laxer in regulation, to be the last word on the matter. And you see this especially in areas like alcohol and tobacco and firearms regulations. the conservative justices tend to find preemption in those areas, so state laws that would attempt to regulate those things usually get struck down as preempted. So another interesting area where you see a split with policy preferences versus states' rights issues. All right, so I think we will end it there, and if you have any questions about the preemption, please let me know, but don't feel overwhelmed by the statutory interpretation part of this. Just work on making sure that you understand the simple supremacy clause argument that's at issue here.